Welcome on behalf of Friday Group, Justice Ramasubramanian. We are very grateful, sir. Give it to that. Sir. Today is 168, sir. 168. Saket Gautam will come and give a bouquet of flowers to our lordships. Where is our staff? Staff wants to give. Come. Ajit, our staff in charge, the laboratory in charge, the overall activity. Please sit down. Madhurima, please. Friends, we are starting now. This is a 168th Friday group meeting. We completed 10 lakhs viewers in our Friday group channel. So 3,000 subscribers we have. Lordship, this is our background. Since 2015, July 10th, we started here. Justice Karpaka Vinayagam was the first speaker. So that was this thing. Now we completed 5 volumes of the registers like this. More than 5,000 physically they attended in this library. In addition to 10 lakhs, whatever in the entire world, that is our little bit introduction. I request Shivani Tushir will say, read CV. You can stand there, no problem.
Justice V. Ramasubramanian was born on 30th June 1958 in Tamil Nadu, India. He graduated in chemistry from Vivekananda College, Chennai, and completed his bachelor's in law from Madras Law College. Enrolled as a member of the bar on February 16, 1983. Practiced for about 23 years in the Madras High Court and was appointed as an additional judge of the Madras High Court on July 31, 2006, and as a permanent judge on November 9, 2009. He was transferred on his own request to the High Court of Judicature at Hyderabad for the state of Telangana and Andhra Pradesh, with effect from 27 April 2016. After the bifurcation and creation of a separate High Court for the state of Andhra Pradesh, was retained as a judge of the Honorable High Court of Telangana at Hyderabad, with effect from January 1, 2019. He was sworn in as the Chief Justice of Himachal Pradesh High Court on June 22, 2019. Was appointed as a judge of the Honorable Supreme Court of India on 23rd September 2019. Justice Ramasubramanian has made immense contribution to the language of Tamil. He has authored a book in Tamil on the principles of law and justice in Kamba Ramayana. He also wrote a series of articles under the caption Beyond Science in a Tamil newspaper for 27 weeks. Justice Ramasubramanian added new vocabulary to the language of Tamil by running a column in Tamil newspaper under the caption Soul Vitai for 50 weeks. The computerization of the Madras High Court and the subordinate courts in Tamil Nadu gained momentum under his leadership. The selection of judges to the subordinate judiciary in Tamil Nadu was entrusted to him 3 times from the year 2012. The decision rendered by Justice Ramasubramanian in Consim Info Private Limited versus Google Private Limited was hailed as the first decision in India on the question of infringement of trademark by an internet search engine through its AdWord policy. This decision was hailed by IPR experts as an encyclopedia on the legal issues involved. On behalf of Friday Group, we welcome you, sir.
Thank you, Shivani. Thank you very much. So we have 119 videos in our channel, Lordships. So that's we are grateful to Subodh Markandeya, senior most person here, and Justice Nagamuthu. And Basant is here. Yes. Yeah, Justice Basant also here. Other prominent members of our bar. And ladies and gentlemen, now we'll go to Lordship without wasting our time. This is for audience. Correction. Okay. This is coming in between.
Very good evening to all of you. It's very easy, after being a judge for about 16 years, it is very easy to listen rather than to speak. And especially to speak in front of, this is Basan, this is Ragamuthu. See, the best way, according to me, to expose your ignorance is to stand in front of the mic. But by force of habit, we commit the mistake again and again, and I am here before you. I think I should start with something very interesting. The topic which I have chosen for today's discussion is law, science and technology. Therefore, I thought I will begin with something very interesting. Can you just pass on these papers? I have not brought many copies. There are about 25 copies. Just to share it with in at least 2-3 copies for every table. If you keep about 3 copies or 4 copies for every table, I hope each table has a paper which I have passed on. Yes? At least one paper in each table. Is it there? Huh? Okay. Are you able to make out anything? You are not able to make out anything.
I've shared the photo with you. Share in the room.
I know that it's not possible to make anything out of what I have passed on. Because it's a mathematical formula. I know, see, when it is very difficult for us to make anything out of law, how is it possible to make anything out of a mathematical formula? I am sure that none of you have deciphered what is that formula about. Alright, let me now tell you what it is all about. Right? Now you can shift your focus from the formula to me. A company by name North Point in United States of America developed a case management and decision support tool. The tool is called Compass. Compass, C-O-M-P-A-S, Compass is an acronym for Correctional Offender Management Profiling for Alternative Sanctions. COMPAS, Correctional Offender Management Profiling for Alternative Sanctions. This tool can be used to assess what is called recidivism. Some of you might have heard about the term recidivism. Recidivism is the tendency of a convicted criminal to commit an offense again and again. Recidivist risk is measured by Compass, C-O-M-P-A-S, on a scale whose formula is what I have now passed on to you. In this formula, now people who have it on hand may kindly take it. You may see in this formula, the letter S represents the violent recidivism risk score. How is that score measured? Now we will go to the next alphabet. W represents the weight multiplier. A represents the current age. A first represents the age at first arrest. H violence represents history of violence. VEDU represents vocational education scale, and HNC represents history of non-compliance. The weight S is determined by the strength of the item's relationship to person offense recidivism that we observed in the study data. Therefore, the explanation of the formula is S is equal to A minus W plus A first minus W plus H violence W VEDU W plus H and C W. Now, you may wonder why I am talking about this formula. The reason why I am talking about this formula is that it has something to do with a case. In February 2013, a person by name Eric Loomis was found in La Crosse, Wisconsin, US, driving a car which was involved in a shooting incident. Not film shooting, actual firing incident. He was arrested. He pleaded not guilty to the charge of firing, but he pleaded guilty to the charge of attempting to flee the traffic police. In determining his sentence, what is the quantum of penalty to be imposed, the judge looked at his criminal record as well as the score assigned by the tool called COMPAS, Compass. Compass classified Loomis, this offender, as having a high risk of re-offending. So, Loomis was sentenced to 6 years in prison. He appealed the ruling on the grounds that the judge, in considering the outcome of an algorithm whose inner workings were secretive and could not be examined, violated the due process clause. The Wisconsin State Supreme Court rejected the appeal. When he moved a writ petition before the US Supreme Court rejected it, saying that it is a developing science, we will not hold it to be unreliable. Therefore, we have come to a stage where sentencing is sought to be determined by a scientific tool using artificial intelligence. Now you know why I passed on this formula and what is its connection with law, science and technology. This is why Chief Justice John Roberts Jr., when he was asked whether he could foresee a day when smart machines driven with artificial intelligence will assist with courtroom fact-finding, or more controversially, even judicial decision-making, John Roberts replied, saying, "It is a day that is here and it is putting a significant strain on how the judiciary goes about doing things." Therefore, science and technology have already arrived here. Whether you like it, you are aware of it or not. To begin with, papers in courts were replaced by electronic records. Then the fact-finding was outsourced to machines. Now artificial intelligence tools have started guiding judicial decision-making process. But let me tell you, it's a very, very vast subject. Therefore, I am not going to talk about information technology today. I just thought I would begin by showing how in courtroom, irrespective of whether I am conversant with science and technology or not, it is already on my table. My focus today is going to be on two things. Number one, how science and technology has impacted, changed the way we look at things. Number two, disputes arising in the field of science and technology. How do we decide those disputes with all our ignorance, not with all our what we are equipped with? But before we plunge into it, let us now find out, is law a science? How many of you would think that law is a science? Law is a science. All right. How many of you think law is not a science? The other people have no opinion until a case comes to them. We will not take a view until somebody pays money to. Science follows a pattern. You arrive at the same result every time you do the same thing in science. But do you arrive at the same result every time you do in law? No. You arrive at different results at different points of time before different judges. Therefore, now tell me, is law a science?
Yes. Yes.
Even now, somebody
Yes.
says this. Oh,
Your Lordship,
yes. That's all right. Doesn't matter.
science is the systematic study of anything.
That is theory.
Yeah.
If that is so, if law is also a systematic study of same thing, when you apply the same facts, two different judges cannot come to different.
Yeah.
I can understand law is a science, judges are not scientists.
But
That's all. We'll come to
but
that.
mind quantum is
Let me
different.
tell you another example. Say there is a case. Let us take a very non-controversial subject. Whether sun rises in the east or west, it goes before a constitution bench of 5 judges. A day may come when such cases may also come up. So by a majority of 4:1, the constitution bench holds that the sun rises in the east. 4:1 means 4 judges say that it rises in the east. One judge dissents. He says it rises in the west. Without being aware of this constitution bench judgment, another constitution bench deals with the same question and decides that this sun rises in the west by a majority of 3:2. Now, let us forget for a moment a reference to a larger bench.
Yes.
Now, in the first constitution bench, 4 judges said east. In the second constitution bench, 2 judges said it is east. In the first constitution bench, 1 judge said it is in the west, 3 judges said it is in the west. So, how many judges, if all 10 judges are put together, how many have decided in the east?
6:4.
How many decided west? 4. Okay. Now shall we take it that the law of the point is sun rises in the east because 6 out of 10 judges have decided so? Shall we take it? Why? If it is science, you can take it. If it is law, you can't.
Now I am also in majority.
Therefore, law cannot be termed as a science because it has a lot of problems. Science uses theorems such as E is equal to mc square. But we also use theorems because our purpose, science uses theorems to make complicated matters understandable. Law uses language to make simple matters ununderstandable. So long as clients don't understand the law, we survive. In fact, there used to be a very famous saying. A professor of contract law asked his students, suppose you give an orange to somebody, what will you tell him? He said, I give you an orange. Professor of contract law said, no. If you give an orange to somebody, you should not say that. You must say, I hereby give and convey to you, all and singular, my estate, interest, rights, claims, title and advantages of, and in the said orange, together with all its juice, rind, pulp and seeds, and all rights and advantages, with full power to bite, cut, freeze and otherwise eat the same or give the same away with or without the pulp, juice, rind and seeds, anything herein before or hereinafter, or in any deed or deeds or instruments of whatsoever nature and kind, to the contrary in any wise notwithstanding. So we make easy things complicated and they make complicated things expressed in a formula. See, we all have bar associations. But what do? The American Bar Association has a section called Section for Science and Technology. This was started in the year 1974 to provide a forum for addressing issues at the intersection of law, science and technology. This section has become a focal point for information and policy on many important issues such as computer and information security law, privacy, cyber security, scientific evidence, genetic research and engineering, biotechnology and nanotechnology. Are we doing that in India? Simultaneously, at the time when the American Bar Association started a section on science and technology, the National Conference of Lawyers and Scientists, NCLS, was also established as a joint standing committee of the American Association for the Advancement of Science and American Bar Association section of Science and Technology. This committee comprises of about 14 members. The goals of this committee are to promote a better understanding of science among lawyers and judges and of the legal system among the scientists. This committee's goal is to make scientists understand law and make lawyers and judges understand science. And it aims at improving the communication between lawyers and judges on the one hand and scientists and engineers on the other hand. In fact, beginning in the year 2006, this NCLS has sponsored a series of judicial education seminars on emerging issues in neuroscience. What has law to do with neuroscience? This NCLS, as I told you, started a series of education seminars on neuroscience. Why should lawyers speak about, think about, study neuroscience? All of us day in and day out we deal with oral testimonies of witnesses. Obviously, a witness, when he gives evidence from the witness box, he speaks from his memory, correct? But how far human memory is reliable? This has something to do with neuroscience. Neuroscientists say that we have several memory systems such as encoding, storing and retrieving. They can also be called working memory and long-term memory. There are certain things which we always remember and certain things which we frequently forget. For instance, how many of you have misplaced your car keys and started searching for it before starting for court? Have you ever experienced forgetting where you placed your car? How many of you have gone through this experience, forgetting where you kept the car keys? The very same persons, I will ask you one question. You forget where you kept the car key, then you find out. But the moment you sit on the wheel, have you ever forgotten to drive?
No.
What is the difference between that part of the memory which forgets where you kept the car key and that part of the memory which always is intact when you drive? You drive because of your memory. You kept your car key, you started searching for it because your memory failed. Why this memory fails and why that memory does not fail? Have you ever thought about it? We don't think about it, but neuroscientists think about it. And it is important for us to understand this neuroscience if you are a trial lawyer and you want to explore why a witness says what he says. According to neuroscientists, people can have memory illusions. You can have an illusory memory without something actually happening. These memory illusions result from normal memory processes whereby some information is lost when the brain compresses information. When the brain actually compresses information, there is a leakage. A leakage occurs. Moreover, memories implanted as a result, neuroscientists say, memories implanted as a result of leading questions or comments and bias which is called retrospective distortions and unconscious influences based on current knowledge and beliefs. These things can easily distort your memory. There is a very famous writer called Helen Thompson. I wish all of you read a very beautiful book she has written. The title of the book is Unthinkable. If you read it, you will really understand it's really unthinkable. She is a science writer, a neuroscientist who turned to be a journalist. Some of her observations in the book about memory, false memory and planted memory. You have false memory and planted memory. They are very interesting. She quotes the example of a cognitive psychologist by name Elizabeth Loftus of the University of Washington. That Loftus conducted an experiment on a 14-year-old boy called Chris. This Chris, a 14-year-old boy, when he was taken to a mall, he vividly recalled having visited the mall at the age of 5, having been lost in the mall, and an old man helping him come back home. This 14-year-old boy, the way he described what happened at the age of 5 when he visited the mall was so startling. But ultimately, this cognitive psychologist Loftus demonstrated that this memory was actually a planted memory. How was that planted? It was made up by Jim, Chris's elder brother, in collaboration with Loftus. Loftus took care of this Chris's elder brother. He told him that you have to say certain things to your brother Chris. Jim fed Chris some of the basic facts of the story. Old man, mall. It was enough for Chris to fill up the remaining details and construct a story. Chris's story showed that it is possible to plant completely false memories into a person's mind. Therefore, if somebody thinks, any of you think that I have an excellent memory, please go back and analyze whether you remember what you actually saw and heard, or your memory is actually a planted one. Ever since that experiment, Loftus has repeated this experiment, implanting all sorts of fake memories, from choking and near drowning to demonic possession. People can imagine that they are drowning. People can imagine that they are possessed by evil spirits. Such things can also be planted in the memory of people. This Loftus demonstrated that even the most educated minds can be manipulated. If your mind can be manipulated, and if you happen to be a witness in a case, how far the court has to rely upon what you say as a witness from your memory. What part of a memory has actually reproduced it. In fact, fake memories can have very serious consequences. There was a reported case where on 15th November 1989, a 15-year-old girl went missing from a school. A 17-year-old boy who was a student and who was absent from the school during the time when the girl went missing became the suspect. After being interrogated for 6 hours, this boy of 17 confessed to the crime. Not only before the police, he pleaded guilty before the court. Therefore, it was not just a confession which could be rejected as inadmissible in evidence. He repeated it, he pleaded guilty, he was convicted. 16 years later, a person who was serving a life term by name Stephen Cunningham, when he was subjected to DNA test in some connection with some other case, he admitted to have committed the crime, and this boy got released after 16 years in prison. It was demonstrated in that case that when people are deprived of sleep, when people are put several leading questions, it is possible to make people confess to crimes which they have never committed. We are thinking of forced confessions where police extract by brutal force. You must remember that without exercising any force, a human brain can be manipulated to make a confession. If you remove police and if you admit this confession, where would you lead to? In fact, this Loftus's experiment showed she took a batch of students from a school. Half of them were allowed a good amount of rest every night for about a week. And the other half were consistently deprived of sleep. What happened was, half of the students who were deprived of a good sleep before the experiment commenced, they confessed to things which they never did. Tiredness, low IQ, leading questions, all of these things can help connive us to forge memory of something that had never happened, is what neuroscience says. So, does it have connection to law now? Certainly has. Another problem is, alright, neuroscience, I have talked about memory. Is there something more than memory in neuroscience to tell us about hardcore criminals? Why people do what they do? This book, Unthinkable, recounts a very interesting incident. In the year 2000, a school teacher by name Luke found himself in a terrible situation. He had developed an increasing interest in child pornography. He began acquiring a collection of pornographic magazines. He started soliciting ladies. He went to great lengths to conceal his activities because he knew they were completely unacceptable. It was only after he had a terrible headache, when the doctors put him on a scan, they found that he had the tumor of the size of an egg in the right orbitofrontal lobe, which is an area towards the very front of the brain. Surgeons put him on the table, they removed the tumor. Just like that, the pedophilic tendency disappeared. After 7 months, he was found to be a no risk to the public, and he returned home to live with his family. That is not the end of the story. A few years later, again he started having pedophilic urges. This time, fortunately, he straight went to the hospital. Scans showed that his tumor had grown back in the same place. Again, a second surgery was performed. With the removal of the tumor, his normal personality again returned. Now what do you say? Who was responsible? Is the tumor responsible for his pedophilic tendencies? If the tumor alone was responsible, it was operated and thrown into the dustbin, it has been punished. But what do you do with Luke? Is a question I don't think any of us will have an answer to. If a medical condition leads a person to do what he has done, I don't think he can come under any of the exceptions, because any of the exceptions like mental incapacity, etc., I do not know whether tumor can really be, I don't think with the existing framework of law, Mr. Basan, I don't think with the existing framework of law, Luke cannot be considered to be a man who is of unsound mind. A tumor in the brain cannot be, I don't know. So how do we deal with such a situation? Once you understand that our personality is not something which is steadfast and strong, but our personality is something which can easily desert us because of medical conditions. In fact, somebody said your personality comprises of three things. One, what others think you are. Number two, what you think you are. And number three, what you actually are. All these three things are completely different, and neuroscience wants you to find out what you actually are. Now let me go to another field. How science and technology has helped crack certain cases. There is a case called Howard Hughes will case. Kevin Evans Nugent was a professor of chemistry at the University of Tampa. In one case, he was assigned the task of analyzing the ink on the last will and testament of one Howard Hughes. He was given the task of conducting an analysis of ink used in the Howard Hughes will and to verify whether it was the ink that could have been used, that was regularly used by Howard Hughes. Why this case became important was, Hughes was a millionaire. He had no family. If a person has a family, he has only 2-3 legal hairs. If a person has no family, he has any number of legal hairs, including lawyers. So his friends thought that Howard Hughes will make a bequest in favor of the Stanford University to which he was dearly associated, or they thought he would give the entire estate to a medical center started by him. But what he did was, under the will, he bequeathed $156 million to a church and another $156 million to a petrol bunk attendant by name Dummer. When the truth and validity of the will was challenged, the will had been executed in 1968. It was found with all the diaries, notings, letters written by Howard Hughes that he always used the pen manufactured by a particular company. That particular company always had the ink in that pen filled up only from another company's manufacturer. But in the year 1970, this company started manufacturing its own ink, and in 1971, it was found that the ink had two kinds of impurities. Therefore, Kevin Evans found out through chemical analysis that the ink used on the will contained the very same impurities which had crept in the ink manufactured by the company which manufactured the pen. Therefore, he found that the ink on the will was of the year 1971, whereas the will itself was dated 1968 and the man had died in 1969. So science gives us some scope for arriving at the truth, though not at all times. How many of you have heard about, now let us move on to another aspect, the legal challenges posed by scientific developments. You have heard about genome editing and the creation of model babies. There is a person by name He Jiangku. He created shockwaves in 2018 when he announced that he and two of his colleagues had altered the genetic makeup of IVF embryos and implanted them into a woman's uterus, leading to the birth of twin girls. A third child was born the following year. In this case, he took up two couple Both the fathers were HIV positive and both the mothers were HIV negative. Eggs were extracted from their body and the twin pregnancy gestated after the genome edited embryos were transferred to their uterus. Genome editing was undertaken to remove what is called the CCR5 gene, which allows the HIV to infect the cells. He used the versatile gene editing technology called CRISPR, I don't want to expand that term, it will be too heavy, to alter the girl's DNA so that they would be resistant to HIV. In the use of this technique, is this use of technique to create model babies ethical, first of all, lawful or not? Unless you make a law, you can't say it is prohibited by law. But law actually follows what society considers at that point of time to be ethical or not. Is the use of this technique to create model babies ethical? How many of you would think it is ethical? Only one. How many would think it is unethical?
I think
Only two.
it's ethical.
Alright, show your hand, that's all. How many of you think it's ethical? Slowly they take. So other people don't want to take a chance. We are not deciding a case. Nobody has engaged you. But the experiment carried out by him to create model babies actually sent shockwaves in China. It happened in China. On 30th December of 2018, the People's Court of Nanshan district of Shengan announced that in pursuit of fame and profit, He and two colleagues had flouted regulations in research and medical ethics by altering genes in human embryos. The court fined this scientist 3 million yuan, equivalent to about $430,000. Collaborators were also sentenced to imprisonment. Health Ministry also banned researchers from ever working with human reproductive technology again, and the Science Ministry banned them from applying for research funding. So some of the scientific developments throw questions of ethics, ultimately leading to regulations or restrictions or prohibitions. Another area which has started throwing up a challenge is what is called savior siblings. How many of you have heard about the word savior siblings? Savior siblings, anybody has heard? Yes, only one person has heard. Savior siblings, my intern is showing her hand. That can't be disqualified. Very unscientific. See, Oxford Dictionary defines a savior sibling to be a child conceived through selective in vitro fertilization as a potential source of donor organs or cells from an existing brother or sister with a life-threatening medical condition. Suppose somebody has a child with a life-threatening medical condition, the couple can go for another baby by selective in vitro fertilization. After the baby is born, they extract a cell from the bone marrow and implant it in the sick baby so that the sick baby becomes normal. But this process, which is to be undertaken when the second child, healthy baby, is at its infancy, is a very painful process for the small infant. For the purpose of making the first baby healthy, how far are you entitled to create a baby, make it undergo a suffering? Obviously, it can't give consent to all that. What happens is this prospective savior sibling is tested for genetic compatibility using what is called pre-implantation genetic diagnosis, PGD, at the stage when it is a fertilized zygote. Only zygotes that are compatible with the existing child are implanted for conception. Then the details we will not go into. In the year 2020, Kavya Solanki became the first ever savior sibling in India. She was conceived to produce bone marrow to save her elder sibling suffering from life-threatening thalassemia. While there is no express law permitting or prohibiting the use of PGD for the creation of a savior sibling, justification for its use may be found in Section 4, Subsection 3, Clause 4 of the Preconception and Prenatal Diagnostic Techniques Act 1994. Therefore, when science advances at rapid speed, we try to find out whether it can come within the framework of about 20-year-old or 200-year-old law. Science goes forward and we go backward. And this section says, no prenatal diagnostic technique shall be used or conducted unless the person qualified to do so is satisfied for reasons to be recorded in writing that any of the following conditions are fulfilled. The pregnant woman or her spouse has a family history of mental retardation or physical deformity such as also. But the problem is this process involves a very painful extraction, bone marrow extraction, or even harmless umbilical cord donation. It can be both ways. Who authorizes? Who is supposed to authorize is a question that none of us can really deal with. But in the United Kingdom, an interesting case came up. The Human Fertilization and Embryology Technology and Authority, which is called HFEA, it regulates the lawful use of modern reproductive techniques to create a savior sibling. But this matter was decided upon by 5 law lords of the House of Lords in a case called Quintawell versus Human Fertilization and Embryology Authority. In a unanimous decision, the House of Lords held that the creation of savior siblings to treat a brother or sister was lawful. The court upheld the Human Fertilization and Embryology Act 1990, under which the authority was set up. This case actually concerns the attempts made by a couple who wanted to produce a sibling with the same tissue type as their son, who was aged 6 years and who was born with thalassemia major. They had 6 unsuccessful attempts at IVF but had failed to produce an embryo of the right tissue type, or the pregnancy ended in a miscarriage. But it was one Josephine Quintawell and her campaigning group who had taken the matter to the courts, claiming that HEFA had no power to license the creation of a baby to save the life of another. While the High Court ruled in favor of the NGO, the Appellate Court overturned its decision. The decision of the Appellate Court was finally affirmed by the House of Lords. Lord Hoffman stated that the technique of taking a single cell from an embryo and testing it for genetic disorders and tissue compatibility was a way to save this family from having to play dice with conception. Parliament never stated that testing of embryos to enable a mother to choose to carry a child with the characteristics of her choice was outlawed. Therefore, the law lords opined that is lawful, at least at that time. There are similar such cases which actually throw challenges. For instance, today in a motor accident claims case, you decide the liability of an insurance company on the basis of the negligence on the part of the driver whose vehicle was insured. But we are moving towards days when we are going to have driverless cars. When you have driverless cars, what would your motor vehicle act do with liability? Is it the manufacturer of the car who will be held guilty of negligence, or is it the auto driving system, something manipulation done, that will be guilty? We don't know. In fact, before concluding, I would quote one other case. There were 2 good friends who were working in a company. At 5 o'clock, when the company closed for working hours, one of them started in advance, the other started after 10 minutes. The person who started 10 minutes early, his car crashed. It overturned and he was in a pool of blood. His friend who followed 10 minutes later retrieved him from the car, called up the ambulance and sent him for treatment. He was found to have suffered a cut in this region, which results in the patient becoming quadriplegic. He became a quadriplegic for life. When she sued for compensation, the insurance company took a very strange defense, and the defense was upheld. The defense was that the friend who followed this car, who retrieved this lady from the crashed car, was not medically competent to take this lady out of the crashed car. She owed a duty only to call the ambulance, and it was only the medical attendants who were qualified to take her out who could have done that. The injury which she suffered at the neck was as a result of mishandling and not directly as a result of the accident. The insurance company established that as a result of the accident she did not suffer that neck injury, but as a result of the handling of the patient by a person who was not trying to handle, that this happened. Therefore, that lady sued her own friend for compensation. Fortunately, she invoked what is called Good Samaritan Neighbors Act. There is something called Good Samaritan Neighbors Act to protect. We don't, at least in our society, every one of us is a Good Samaritan. Irrespective of whether what we do causes harm or it helps the patient, we do that. She had to take refuge under the Good Samaritans Act and claim immunity on the ground that what was done by bona fide belief for saving the life of a patient should not lead to a claim for damages. So, dear friends, today the way we look at things has to undergo a complete change because of science and technology. The challenges posed by science and technology are ever growing. With we lawyers and judges are completely disconnected and completely deficient in handling such cases. In fact, in a very famous case in 1998, Daubert versus Dow Chemicals, Dow Pharmaceuticals, the US Supreme Court said, what are the functions of a judge when two experts are pitted against each other? Our section 45 of the Evidence Act says it's only a relevant fact. But that was at a time when science and technology had not developed. Today, if you have to deal with a case arising out of environmental law or a nuclear power plant, you would naturally look into scientific evidence. Scientific evidence is provided by experts, but there are experts who are prepared to provide evidence on both sides. Unfortunately, lawyers alone take the blame. The experts are let off the hook. The experts are no less culprits when it comes to evidence. Therefore, the US Supreme Court has evolved a formula where how the court has to function as a gatekeeper in determining at the threshold what is the kind of expert whom you can allow to testify and who is the kind of expert whom you cannot allow to testify. Unfortunately, we have not gone so far, and we treat everything alike. So with these few words, I take pleasure in being part of your Friday group. Thank you very much.
What we are saying is correct.
Lordship, we are highly grateful to you. The way science and technology you explained, it's quite interesting. You created interest, and scientific approach you are given to lawyers. So let us give a standing ovation to Lordships, please. Please. Mr. Debashish Haruka will give vote of thanks. Please sit. And after this, because of billion and 10 lakhs viewers, we are distributing seats. Kindly stay here. Then after that, we'll have a cup of tea also, with Lordship. Just a minute. My Lord, go, please. Please.
My Lord, Honorable Justice V. Ramasubramanian, respected seniors at the bar and dear colleagues. My Lord, Honorable Justice V. Ramasubramanian, respected members, respected seniors at the bar and dear colleagues. I was sitting at the back all through, my Lord, and I was watching quite carefully, apart from of course listening more carefully. Normally at the end of a heavy day work, having a whole bunch of lawyers sitting and hearing on an issue of law does happen, but with a pin drop silence on the issue of science and technology is something which only my Lord could have done. And with the clarity and the whole wide range of issues connected in such simple words with law and science and technology is something which is mesmerizing, and we are truly grateful for this intellectual treat this evening by my Lord. In fact, my Lords would recall Steve Jobs, the Apple founder. So he was really known for this distorted reality field. And what he would do is, if somebody comes up with an idea, he would immediately dismiss him with almost contempt. And a week later, he would come back saying, I have this brilliant idea with me. To the extent that the originator would really wonder whether it was his idea or actually it was his boss's idea. So, my Lords, there's so many of these issues, and we are truly grateful, my Lords, for taking out time today, this evening, for us. With the sincere efforts of our learned friend, my Lords, just 2 days back, we have reached 1 million views on the YouTube channel. And we are hoping that we'll go further and we'll be able to have more of these sessions with my Lord. Thank you so much for this time.
You open this seat, we distribute to our members. You just open, Lordship. With Lordship hands, we will take our seat 7. Just give it to back side. Wait and just give it to back side. Back side. Or further back side. Back side then. Back side then just wait for something. Yeah. Yeah, we'll give it to you. So first you can take this. Yeah.